Years answering the Northland's toughest legal questions, helping you understand where you stand. Falsani Balmer, Peterson, Quinn, and Beyer.
Good evening, and welcome to Lawyers on the Line. I'm Paula Polasky, a lawyer with the Falsani Balmer, Peterson, Quinn, and Beyer law firm, and this evening's moderator. Tonight's topic is Social Security. Making a claim for Social Security benefits is not always as easy as it sounds, especially if you get denied. Knowing about eligibility requirements, medical evidence, appeal procedures, and vocational evaluations can make all the difference. Now, I'm pleased to welcome our panelists tonight, Sean Quinn of the Falsani Balmer firm, Stephanie Balmer of the Falsani Balmer firm, Ed Utities of Utities Rehabilitation. Sean, Stephanie, and Ed will respond to your questions about Social Security. Please call us at 218-788-2844, or if that's long distance for you, call our toll-free line at 1-877-307-8762. Now, to start off tonight, I understand that there are different types of Social Security benefits. Sean, I'll start with you. SSI, RSDI, what's the difference between these?
Okay, well, of course, we're talking about Social Security disability benefits, and that's the whole program tonight. But RSDI stands for Retirement, Survivor, and Disability Insurance, RSDI. And we'll be talking about disability. That's the benefit that the disability aspect of it is the benefit that is paid to people who are disabled, and the amount they receive is based upon how much money they paid into the system by paying their Social Security taxes. SSI is Supplemental Security Income, and that is a welfare program. And people who are disabled and who qualify for welfare financially can get SSI. So that's the primary difference. One, SSI, it's the same amount for every person in the country. It's right around $730, $750 a month. RSDI, disability insurance, that it can be as low as just a couple $100s a month. It can be as much as $2,500 a month, depending upon how much you paid in Social Security taxes. So those are the two types of programs.
Okay. So Stephanie, what does it cost to hire a lawyer for a Social Security case?
There are statutes that govern how representatives are paid. Generally, the deal is that once you hire a representative who doesn't necessarily have to be a lawyer, you sign a retainer agreement that says the representative will get paid 25% of your back pay up to $6,000 currently. $6,000 is the cap right now. And that's contingency based essentially, which means if for whatever reason the claim isn't won or resolved favorably, then we don't get paid. If we do recover the benefits on the injured person or the disabled person's behalf, then the feds pay us directly out of the back pay. That's about it. Frequently, we also spend money working on the case, collecting medical records, getting reports from doctors. Sometimes you have to pay for other types of records. And there's a statute that controls how much you have to pay for these things. Generally, it's $10 for a set of medical records. And frequently, the disabled person will also have to reimburse on top of the fee. But that about covers it, I think.
Yeah, and I would add one other thing. What Stephanie just said is 100% correct. This 25% and the $6,000 cap applies when the lawyer says, I want to get paid directly by Social Security if I win the claim. A lawyer can instead say, you know what? No, I'm going to charge 25% without a cap, but then they have to ask the judge to approve a fee, and it's a long, drawn-out process, and oftentimes the judge might even award a lower fee. So every lawyer that I know, every representative I know does exactly what Stephanie described.
Okay. And the Social Security judge does generally have to sign off on the representative getting paid. If the case is decided favorably before the judge gets the file, there isn't as much of a review process. And then also, unlike in workers' compensation, if you needed a representative to get you on the benefits, They'll get paid out of your back pay, but then they will not get a chunk out of your monthly benefit. The representative getting paid stops at that point. And a lot of representatives will help people, get everything off the ground, but they don't get paid out of the ongoing stream of benefits.
Okay. So Ed, let's talk a little bit. What is a vocational expert? And how do you get qualified or certified by the Social Security Office?
Well, first of all, Paula, thank you for having me here.
Thanks for being here.
Yeah, a vocational expert is basically someone that's had a number of years of experience in terms of performing vocational evaluations, job analysis, wage loss analysis, someone that's familiar with the labor market, the federal labor market, along with the state labor market. And typically, VEs in Minnesota normally will have a master's degree in voc rehab or related field. And most of the VEs in Minnesota have at least 20 plus years of experience. A VE can have certifications through various certifying bodies, but the primary criteria is to have that long-term experience in terms of doing vocational evaluations, if you will.
So what would you do at a Social Security hearing? What is your role?
My role is to be an independent, unbiased expert. I'm not hired by, I don't represent Social Security. I don't represent attorneys, for that matter. I'm there to give my my honest, unbiased opinion based on questions that the judges will throw out at me normally at the end of hearings, and questions that the attorneys ask me at the end of those hearings also. Also, I'm there to classify a person's work, whether it's sedentary, light, medium, heavy, or very heavy work, whether it's skilled, semi-skilled, or unskilled. And if it is skilled work they've done in the past, or semi-skilled for that matter, what are those transferable skills, and can they transfer over to other type of work? That's essentially what I'm doing there.
Okay. Is there anything that you shouldn't be asked at a hearing? Anything that's off limits?
Well, yes. With some of the younger attorneys or attorneys that don't do a lot of Social Security work, I get typical questions that I can't respond to. Questions like, would someone hire me? Well, with Social Security, as Sean and Stephanie know, it's not a question of whether or not someone would hire you. It's a question of whether or not a job exists and can you do that job. And the same type of thing, if I'm asked a question, well, are there any job openings for these types of jobs? My response there is I'm not allowed to address that, because according to this program, it's not a question of whether or not there are job openings. The question is, are there jobs out there that exist? And if a person can do one or more of those jobs, then that would fall within the criteria. Normally, if you're unrepresented or you have an attorney that is not familiar with the system, sometimes those questions come up.
Okay.
Yeah.
So Stephanie, we talked sometimes about how long it takes to get a hearing. Why does it take so long to complete a Social Security case?
That's a good question. I usually, when someone is talking to me about the process, to try to keep it brief, when you initially apply, the local field office is meant to get a decision back to you hopefully within a couple of months. Sometimes it's sooner, once in a while it's longer. And then you appeal, and again, hopefully a couple of months. Very frequently there it is sooner, because almost always they simply affirm the initial decision. Then the real delay is between the second appeal, also called the request for hearing, and the actual hearing itself. Sean's assistant actually did the math the other day, and on average right now it's taking about 17 months. I forget if it was between the initial application and the hearing, or if it was
from the request
for hearing and a hearing. So that's almost a year and a half. And it's taking a long time because the system is overwhelmed. Sean actually teaches a class where he discusses this point in detail, and I'm sure he'll correct me if I'm wrong.
No, I won't.
Okay.
Well, you won't be wrong.
Oh, yeah, never wrong. That's right. Thank you. And we have a lot of baby boomers who are becoming disabled right now, and so with without the resources to keep up with the number of people who are becoming disabled. I also have my own theories. I think, when we had the recession and people were getting laid off, it forced people to realize the level of their disability and the futility of finding replacement work. So those are the two main answers, I think.
And I think that's fair. What really happened in a real short version is the clean version is, despite the Social Security Administration, the folks that run the Social Security Administration saw the storm coming for years and years and years, and they kept telling Congress, you got to give us more money to hire more staff people at the field offices, to hire more judges and more judges clerks at the hearing office. And Congress ignored those pleas for years and years and years until the backlog became overwhelming. And then they finally started hiring more people. They started modernizing, making it a computerized system instead of a paper system. And then just as things were starting to catch up and waiting for a hearing was maybe close to a year, the recession hit, as Stephanie alluded to, and a lot more people were applying all of a sudden, and now we're back to a year and a half. It's very unfortunate.
And there isn't anything we can do to speed it up. That's an unfortunate conversation we have to have with our clients.
Yeah.
And I have it over and over again, because if you're disabled and not able to work, not many people can hang on for a year and a half. People have to move in with people, declare bankruptcy, and you can't make the system go faster.
Question from Virginia. Sean, I'll give this to you. Can I work while I get SSDI?
For SSDI, the regular benefit, the answer is yes. For SSI, the answer is also yes, but it's a slightly different yes. To be disabled, as Social Security defines it under either program, it means you can't work full-time, or it means you can work part-time, but you can only make up to, say, approximately $1,000 a month. I think the actual number is closer to $1,100 nowadays. And if you can't make more than that, or you can't work full-time, you're considered disabled. So for the regular disability benefit, theoretically, you can make up to, let's say, $1,100 a month and still be considered to be disabled. Same for SSI. The closer you are to that number, the more likely you will get denied, because the judge will say, well, if you can make $1,100 a month, then you could probably make $1,150 a month, which will put you over the top, or something like that. I just had a client have that conversation with her earlier today. If let's say you're making $700 a month and you're getting the regular disability benefit, that's probably going to be okay. And if you win your Social Security claim, you'll continue to get your full disability benefit plus whatever that take-home pay is. For SSI, if you make, say, $700 a month, Social Security will say, well, if you're making $750 from work, we're going to cut that in half, $350, and we're going to reduce your SSI benefit by $350. So they take away 50 cents of your SSI for every dollar you make. It's approximately that.
And oftentimes, too, at those hearings, if a person's working close to that limit on a part-time basis, the judge will typically ask, well, would your employer be able to accommodate more hours for you? He wants to know, point blank, is this person intentionally keeping their hours down so they qualify?
Right.
So that's another factor that has to be considered, too.
Right. Well, and here's another question for you. Do you really need an attorney at a Social Security hearing? What are your thoughts on that?
Well, being a non-attorney, it's a good question for me to deal with, I think.
Yeah.
I've been doing this for a little over 30 years now, and what I've seen over that time frame is approximately somewhere between 80 to maybe as high as 90% of claimants that are appearing at those hearings have attorneys or representatives. You don't need to have a representative. You can go in there yourself, and the judge will act essentially as a fact finder in those hearings. But I think it's, in my opinion, it's best to have a representative at the hearings, because if you go in there by yourself without a representative and you don't know the system, you really don't know the types of questions that you should be throwing out on the table. As I mentioned before, typically an unrepresented person will say, well, who will hire me? they don't know that that's not a criteria. It's whether or not you can do the job, or are there any job openings. That's not a criteria. And that person thinks it's a legitimate question, but in essence, it's non-material to the hearing process. So there are a lot of advantages of having a representative at those hearings, and as I mentioned before, 80 to 90% of cases that I've seen in the past do have representatives.
Now this question comes from Hermantown. I'll throw it to you, Sean, and it's about age. I know age is kind of a big deal in Social Security. She asks that she's 61 years old. Should she apply now or wait till she's 62?
Well,
62 kind of
yeah.
a magic number, and why is that?
Well, 62 is the age in which an individual can begin receiving their retirement benefit, although they take a substantial reduction from the full benefit. The regular Social Security benefit, the DIB benefit, the RSDI benefit, that is your full retirement benefit, your age 67, 68, 69 benefit, whatever age it might be. That's your full benefit early because you're disabled. So she's certainly at an advantage to apply now, because number one, she would get it sooner now versus a year from now. And number two, she'll get $1,200, $1,300 a month instead of $700, $800, $900 a month because of that reduction. Some people apply for the disability benefit at that early 60, 61 age, and they get denied. And they're going through this long wait that we talked about. And then they turn 62. Okay, go apply for your 62 benefit now if you want, and then we'll keep pursuing the disability claim. And if you win the disability claim, your rate will get jacked up to the full rate, and they'll owe you the back pay from when they should have started it in the first place. So she's at a huge advantage to apply for the benefit now.
Okay. So Steph, another question that came in. This person got Social Security disability at age 55. When they turn 62, do they get the same amount as they did? I'm guessing they mean between 55 and 62, or does it change at that point?
Well, it depends.
Does it
Sean
depend?
and I, yeah, the lawyer answers. Sean and I were just talking to a client about this yesterday. Do you want to take it?
You mean the 50? Well, she's going to keep getting the same benefit.
You still have to prove that you're disabled. It's not as simple as just switching it over.
Well,
If they
I think
were
this
disabled
is
at
someone who's
55.
already disabled at 55.
Oh, she's on
Yeah.
SSDI.
So the answer doesn't. It depends at all.
Well, it
She'll keep getting the same benefit, and when she turns 62, it'll still be called disability. And when she turns 67, or again, Social Security keeps ramping up the full retirement age. But when she reaches full retirement age, the label will change, but the amount will stay the same,
Right.
with cost of living adjustments every year too. So, yeah, we were talking yesterday about somebody who.
yeah, I didn't understand the question.
Yeah.
Okay.
Okay.
So another caller, this person is now divorced. They were married for 14 years. Is she eligible to draw from her husband's Social Security benefits in any way if he's still working, or how does that work?
She's
10 years. 10 years.
Yeah,
Yeah.
she's divorced now.
Yep, divorced, and they were married for 14.
Yeah. Part of it depends on how old she is.
Okay. Why is
Divorced spouses can draw on the account of their ex-spouse, and the sexist viewpoint is the divorced wife can draw on her ex-husband's, but it works the other way too. But you can draw on your ex's account if it's higher than your own, and you're over 50 and you're disabled. Or I think it's 60 or 62 if you're not disabled. And then you can draw on your own account or your ex's account, whichever one's higher.
But don't you also have to be married at least 10 years, though?
Yes, and you have to have been married at least 10 years. And then you have to not be remarried as well. If you remarry, reset.
Okay. Okay.
Not to discourage people from remarrying. If they want to remarry, they should do that.
Right.
This isn't family law.
Right. Right. A woman from Hibbing asks, what are these grids she keeps hearing about? Steph, do you want to take that one?
Sure. So there's a couple different ways to be considered disabled. The first way is to what's called meet a listing. If you have a, well, actually, the first way I would say is to have a condition that's on the compassionate allowance list. So there are these lists where if you can prove that you have this condition, it's just such a rotten condition with such a bad prognosis, there shouldn't be a lot of pushback as far as getting you on disability benefits. The next way is to meet a listing if you have a condition that's also severe and fits really precisely within a number of conditions that are considered regulations by the Social Security Administration. The third way is to fall in these grids, and they are literally grids. And what you need to know to find out where you fall in these grids is your age, your education, what your work capacity is. Ed had mentioned sedentary, light, medium, heavy, and very heavy. And then some other factors. And you can be plugged into these grids and find out if you're considered disabled, considered not disabled, or if it's kind of up in the air.
And the grids change at different age levels too. At 50, less than 50 years of age, you're considered a younger worker. And it's a lot harder to qualify, in that it basically boils down to, can you perform just some basic assembly, packaging types of functions, real easy type work for that matter. At 50, 55, and 60, the criteria is lessened from the earlier ages, but there's still some factors you have to consider. The other part of the grids that Stephanie mentioned is skill level, whether it's you've had skilled, semi-skilled, or unskilled work. Yeah.
Yeah. So. Any more detail on that, Ed, about how you classify jobs by skill level, exertion level? What sort of things do you look for as a vocational expert?
Well, one of the primary things is there's a number of publications that are supplements to the Dictionary of Occupational Titles. I use the classification of jobs according to work and trade factors, and that
Bestseller.
Pardon? Yes,
It's on my nightstand.
You know, actually, Sean, it's out of print right now.
Oh,
And the one I have is, I've gone through 3 of these already, and the one that I have right now, all the pages are turned over and whatever, but you can't get it anymore. But it has what's referred to as a specific vocational preparation number listed for every job within the national economy. Jobs that have numbers of 1 and 2 are considered unskilled, 3 and 4 semi-skilled, and above that skilled. That's one way of classifying it, and basically it boils down to is how long does it normally take to learn a job, either through on-the-job experience or formalized education. So that's the primary aspect of how we classify it.
There can be some degree of discussion at a hearing about this too. That's one of the things that I know Sean and I both cover with our clients, because you know, one of the issues that will have to be decided along the way is whether an individual can do what's called their past relevant work, and then also whether the skills that they had in Ed's dictionary is actually what the skills in other words, Ed's got these books and he's got these resources, but sometimes real life is totally different from what Ed is operating on.
A good example of what Stephanie's saying is you can take the job of a bar manager. That's considered a skilled occupation, but that's primarily dealing with someone maybe that's running a bar down in the Minneapolis-St. Paul area where he's got 30 or 40 employees and he's doing all kinds of bookkeeping work and interviewing, hiring and firing, if you will. And if Stephanie's got somebody that basically is running a small mom and pop bar up in Virginia, Minnesota with their children working there and maybe 1 or 2 employees, that's a horse of a different color and would probably fall under a semi-skilled classification as opposed to skilled.
I wanted to add one more thing to the grids. I'm sorry. That really only references physical ability. So if someone has physical limitations, sedentary, light, medium, etc., but they also have what I call behavioral health or mental health limitations, those don't fit in the grids. They can affect some of the factors, but that takes it into a different area of analysis. Okay. That's all.
Looks like we have time for maybe one more question. Sean, this woman's husband has been disabled since 1992. He's now 71 years old. She had to quit her job to care for him. Can she receive any sort of benefits, or what's her situation like?
Well, Social Security doesn't pay for things like, having somebody take care of you other than what Medicare might cover. But she may be eligible for benefits on her own account if she worked, or on her spouse's account. I'm trying to think of the rule off the top of my head, but I think married spouses, you have to have a minor child, which I'm suspecting they do not. And I'm trying, off the top of my head, I can't think of any other qualifications that would allow her to draw on her husband's account while he's still alive. So
She may be able to talk to the county. Sometimes the county will pay for caregiving. That's not
Yeah.
Social Security,
Yeah.
separate issue, but I would recommend she do that.
Okay, really good recommendation. Looks like we're winding down on time here. All right, that's all the time we have for tonight. Remember, you can watch our show again online at www.wdsc.org or at www.duluthtriallawyers.com. Please join us again next week when we'll be talking about premises liability. I'd like to thank our panelists for their expertise this evening, and thank you for watching. I'm Paula Polasky. Good night. What are your rights and obligations if you're hurt on someone else's property, or if someone is injured on your property? We'll be taking your questions about premises liability on the next Lawyers on the Line, Thursday night at 7:30 on PBS North. What are your rights and obligations if you're hurt on someone else's property, or if someone's injured on your property? We'll be taking your questions about premises liability on the next Lawyers on the Line Thursday night at 7:30 on PBS North.